A German court just said something that the entire AI industry has been hoping nobody would say out loud. When an AI generates a false answer and puts it at the top of your search results, that's not a platform hosting bad content. That's the platform making a false claim. That distinction might sound like legal hair splitting, but it's actually load-bearing for a pretty significant chunk of how AI products are built and deployed right now. The court ruled that Google's AI Overviews feature is Google's own speech, not aggregated third-party content, not a neutral conduit, Google's words. And if those words are false and they harm someone, Google is liable for them. Most of the coverage on this has been framed as Google loses a case in Germany, which, sure, that's true. But I think the more interesting thing that happened here is that a court drew a legal boundary around a new category of content, AI-generated synthesis, and placed it on the author side of that line rather than the platform side. That is a very different legal world than the one the AI industry has been quietly building inside. To understand why this matters, you have to go back to the legal framework that made modern search possible in the first place. In the US, Section 230 of the Communications Decency Act gives platforms broad immunity from liability for content their users create and post. The EU has analogous provisions in its e-commerce directive and, more recently, the Digital Services Act. The basic idea is, if someone posts a defamatory comment on your platform, that's their speech, not yours, and you're not on the hook for it unless you had specific knowledge of it and failed to act. This framework allowed Google, Facebook, YouTube, and the rest of them to scale without reviewing every piece of content before it went live. It was a pretty reasonable policy trade-off for the early internet, and it's worked more or less as intended for user-generated content. But here's where it gets interesting. Google's AI overviews don't work like that. Nobody typed that answer. No user submitted it. Google's own system synthesized it by ingesting sources, running them through a model, and generating a novel text output that sits above all the actual search results. The court's reasoning, as reported, was essentially, you made this. You wrote it in the sense that your system produced it from scratch. The traditional platform immunity defense requires that someone else authored the content, and in this case, nobody else did. So the defense doesn't apply. Okay, so what actually happened in this case? Based on the reporting from the Decoder and Ars Technica, the case centered on a specific false claim that Google's AI overviews generated about a real person. The AI-generated summary produced factually incorrect information that damaged that person's reputation, and the court found that Google, not some third-party source, was responsible for having made that claim. The court's framing, as reported, was pointed. It said that nobody needs AI to search the internet, which is a pretty direct rejection of the idea that AI synthesis adds value that justifies relaxed liability standards. What the court was getting at is that the synthesis layer, the part where Google's model takes source material and generates a new, original-sounding answer, is where the legal risk lives. Because when that synthesis goes wrong, which it doesn't produce a link to a bad source that the user can evaluate. It produces a confident-sounding declarative sentence with no visible provenance, sitting at the top of the page, carrying Google's implicit authority. And that's the mechanism the court is targeting. It's not that AI search is wrong to do. It's that when you insert a synthesis layer that generates novel claims, you can't simultaneously claim to be a neutral platform that's just passing along what others said. You're doing something more than that now, and the court is saying the liability should follow the function. Now, the industry counter-argument here is real, and it deserves a fair hearing. AI overviews, and really any RAG-based answer interface, are probabilistic systems. They're not asserting truth the way a journalist or a doctor asserts truth. They're doing something more like, here is a synthesis of what a large set of documents tends to say about this topic, with some statistical uncertainty baked in that the user isn't shown. Holding a probabilistic summarizer to the same defamation standard as a newspaper is arguably a category error, and it could seriously chill the development of genuinely useful search features. That's a coherent position. But I think it fails on one important point, which is that the product doesn't present itself as probabilistic. It doesn't say, here's what the documents tend to say. Treat this as a rough summary with uncertain reliability. It says, in Google's own interface design, here is the answer. The confidence is in the product design, not the underlying model. And once you've designed a product to project that confidence to users, it's a little hard to then turn around in court and argue that it's actually just a fuzzy statistical process that shouldn't be held to truth standards. The court seems to have noticed that gap between what the system signals to users and what the system actually is, and that gap is where the liability landed. So, where does this leave us? The ruling is German, which means its direct legal force is limited to that jurisdiction, but I don't think you can dismiss it as a Germany-specific problem for a few reasons. First, the EU AI Act has liability provisions that are still being interpreted, and rulings like this one feed into how European courts and regulators will read those provisions going forward. If German courts are already treating AI-generated text as first-party speech under existing law, the AI Act's higher-risk tiers are likely to land similarly. Second, the US is different, and Section 230 is a real and meaningful difference. But US courts have been chipping away at platform immunity in narrower ways for years, and a well-reasoned foreign precedent establishing a clean liability theory for AI synthesis is exactly the kind of thing that plaintiff attorneys in US cases will cite. Third, and this is what I'd most want practitioners to hear, this ruling's logic doesn't stop at Google. It applies to any product that inserts a synthesis layer between source material and user-facing answers. That's Perplexity. That's ChatGPT Search. That's Bing Copilot. And honestly, it's any internal enterprise RAG tool you've deployed to answer factual questions for employees or customers. If your system generates novel declarative sentences from source documents and presents them confidently to users, the court's reasoning maps onto your product. The question your legal team should be asking right now isn't, does this ruling apply to us in Germany? The question is, do we have a synthesis layer, and if it generates a false factual claim, who authored it? Because this court just gave one answer to that question, and it's the answer that was always logically true even if nobody had said it in a courtroom before. If you're building a product that surfaces AI-generated answers to factual queries, here's how I'd think about your exposure after today. If you're operating in the EU or serving EU users, you're probably in the same liability bucket as Google under this ruling's logic. That means your legal team needs to know you have a synthesis layer if they don't already. On the engineering side, the mitigations that help most are also the ones that make your product better anyway. Inline citations tied to specific source passages, explicit confidence signals or hedging language in the UI, and robust fact-checking pipelines before high-stakes claims reach users. If your RAG pipeline is generating answers without surfacing where those answers came from, that's now a legal design choice, not just a product one. And if you're in the US and thinking this doesn't touch you, I'd watch how US plaintiff attorneys engage with this ruling over the next year. It's a clean legal theory, and it's going to get tried. That's your evening context. See you tomorrow.